Hello, everybody. This is Ted Murmagos, and this is the June Child Support Connection. The June Child Support Connection, June 2022. Thank you for those of you who have waited patiently as we dealt with some technical difficulties here at the Child Support Office. I hope that you've stayed linked to us and that you have some questions for me here at the Child Support Office. And so it's about 10 after 12, so we're about, 40 minutes a little late. But we will go ahead and stay on till 1 o'clock if there's questions and there's things that I can help people with. And if we need to go a little longer, we can certainly do that. The whole point of the Child Support Connection is to help people with child support questions here in the First State. As I always like to do, I would like to read our mission statement. I know that if you've watched any of the videos that we post on our Facebook Live page, that you've heard me do this before. I'd like to do it every month so that people who are tuning in for the first time know that we here at the Division of Child Support Services in the state of Delaware, we have a mission statement. And it's our mission here at the Division of Child Support Services to deliver quality customer support by partnering with families to improve the lives of their children and, of course, the family unit. This is achieved through obtaining accurate child support orders to meet the financial, medical, and emotional needs to promote family self-sufficiency and, of course, the most important thing, the best outcomes for children here in Delaware and for those children around the country. So we certainly work hard to live up to that mission statement. As the division director, it's my hope that all of our employees do their best to meet that high level or that high bar to try and support families here in Delaware. So I always like to read that mission statement to let people know we have one and exactly what it focuses on and what are the things that we intend to try and do as we serve the public. I had a question posed to me the other day about how to apply for child support. So, I wanted to run through quickly how a person can apply for child support services here in Delaware. The first way is, and this probably is the way that affects most people, is by filling out a child support application. You can call our office at 302-577-7171 to obtain a child support application. And those applications will be mailed to you, or you can come by our office and pick one up. If all the parties live in Delaware, it's relatively a pretty simple process to fill out the application. It's basically simple, and you can return that application back to our office. And we need some supporting documentation like birth certificates or marriage certificates or divorce decrees and that kind of thing. But you can pick up an application at one of our three offices, and our three offices, we have one in each county. And you can call our customer service unit at 302-577-7171, and we would absolutely mail you a child support application. Now, there is a one-time $25 application fee, but you would never have to pay for a filing at family court. You never have to pay a fee to receive any of our enforcement tools. So that's one way to become a client of ours. I see we have a question in the chat, and because we're a little bit delayed here, I want to go make sure I hit that question really quick. So the question is, if a child support order states this order is to be modified upon motion of father, let's see here. If a child support order states this order is to be modifiable upon motion of father, providing proof of birth of child outside of this order, what paperwork is needed to file the motion? In all 3 family courts, there is a pro se office. And my recommendation would be for the father to go into that pro se office and actually talk to a person in their office about what the appropriate documentation would be to file. It may be just a general motion that can be just filled out with the specifics of that particular case and filed with the court. Whenever you file a motion at family court, though, you have to send a copy to the other party, and in some cases the child support office, so that we can be aware, and the other party, the mother or the custodial parent, can be aware. But my recommendation would be to go to the family court and talk to their pro se office, or they also call it a resource office, and they would be able to help you file that motion. Here at the child support office, we have like generic motions that basically we just type in what the specifics are. I'm also thinking that you would reference the previous order. In the previous order it said, blah 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 blah, and here's the information that we're providing. That's probably the most important thing too. When you file that motion, you want to attach any documentation that proves the point that you're trying to make within that motion. So I hope that was helpful. And it gives you a little bit of insight. Filing a motion, going to family court and speaking to somebody, they can help you walk through those steps and help you file it with the family court and mail copies to the other parties involved. The next question is, I see Miss Lena said hello. Hi, thank you for joining us today. This is the next question. I tried calling this morning and it kept saying call failed. I was unable to get through or even send a voicemail to leave a message. That's odd. And we were having some technical difficulties getting on the Facebook Live today. I'm wondering if there's some technical things going on with Verizon or with the telephone services here. My suggestion would be this. You can certainly try back and contact the child support office. And if you're looking for someone specifically, I would try calling our customer service unit at that 577-7171 phone number. And then having them pass the child support specialist in that customer service unit can pass a message along to your worker. Additionally, this seems like a great opportunity for me to promote our child support website. And if you're not signed up to use our child support website, I strongly suggest you do this, because you can actually type an email message to your worker and they can respond to you via that same process. But if you go online and you type in my.delaware spelled out .gov, you can create a username and password, and then you can download basically our child support website, our customer website, to that app, my.delaware.gov, and you can actually have information regarding your child support case. You can actually see account statements and print them at home. You can send messages, like I said, to your worker, and they can respond to you. And then you can actually get letters and pieces of information from us through that child support website. So please, I'm encouraging anyone who's seeing this video, if you have a child support case here in Delaware, go to my.delaware.gov, and then on the left you'll be able to download to that site the child support website, the child support customer website, and actually have access to your child support case. And then the third way, if you really wanted to get a hold of your worker and you can't do it through the normal phone process, is send us a message through this Facebook Live event, a private message, and we'll make sure you're with your case number, and we'll make sure it gets to your worker. Let me just see here. I want to follow up with her, and then I'll go back up. Let's see here. What if the father prolonged the process after a hearing to continue paying mother directly? Instead, after the hearing, decided to start going through child support office to have a wage attachment, only to quit job and avoid the wage attachment. What are the next steps so early in this process? Okay, so if the family court has issued a court order, I always say this when I'm on the radio with Jake Smith or talking to a non-custodial parent. When the family court issues a new order, they direct that all those payments, and this happens in about 99% of the cases, that those payments should be directed through the child support office. And one of the things we do for all of the cases in our system is we will generate a wage withholding when a non-custodial parent changes a job. So I'm trying to go through this question again. What if the father prolonged the process after a hearing to continue paying mother directly, instead, after the hearing, decided to start going through child support office and only to quit his job to avoid the wage attachment? What are the next steps? My suggestion when we talk about next steps is this. If he is collecting unemployment, the Division of Child Support has an interface with our unemployment department here in the state of Delaware. So if he's collecting unemployment, we can attach a certain portion of his unemployment check to pay child support. But if, going back to what I said previously, if the courts have ordered that payments need to come through the child support office, that's what the non-custodial parent should do, to have an accounting record of all of those payments. Obviously, we don't want to see people quit when a wage withholding comes to their employer. If you know of a new employer, or if the non-custodial parent wants to call us with a new employer, we can certainly generate a new wage withholding to a new employer. Ideally, if the non-custodial parent quit his job and we do not receive regular child support payments from a new employer or from him or her directly, we can, if you're a client of ours, generate a contempt petition with the family court after, I think it's like 30 days of no payments, 30 to 45 days of no payments. If you are not a client of ours, I suggest you become a client, or you can go to family court and also file a contempt petition for the non-custodial parent's failure to continue to make child support payments. So those are my suggestions, and I hope that I was able to help. I'm going to go back up one person. And this question is, well, what if I haven't received our child support in years, and we have gone to court and he still refuses to pay? He quits his job, so he won't pay and the child is now over 18. First things first, in the state of Delaware, the age of emancipation is 18, first and foremost. If that person is still in high school, that child is still in high school, if they're 18 and still in high school, that order would end for current support only when the child graduates from high school. But if the child is still in high school and is going to be 19, at 19, all child support for current support ends. The important part of this is that any arrears that accrued, and arrears accrue when the non-custodial parent fails to make that current support obligation each month. Anything that's left unpaid becomes an arrears balance. That arrears balance will stay on the books until it is paid in full. So some non-custodial parents, like you're describing here, will change jobs or quit jobs and tries to avoid paying. But it's what I always try to encourage non-custodial parents. This debt does not go away, and you're going to be required to pay it until it's zero. So you might as well start paying it and making an effort to get that arrears balance down to zero. Similarly to what I've mentioned previously, if this individual fails to pay the obligation, and you're a client of ours, you should let your worker know, and we can go into family court again and file, with another contempt petition. I can tell you this from experience and seeing this happen to other non-custodial parents. The more they blatantly disregard a family court order, The family court does not obviously like to see that happen, and the level of things that can happen to a non-custodial parent can get worse. And it's up to the court. They have this discretion. They can incarcerate someone for failure to pay their child support. So, the more times that he or she, says, I'm not going to follow that court order, the more times the court sees that, and they basically can say, we've had enough, and incarcerate somebody. So that is something that can happen. So my suggestion is always to reach out to your child support specialist, see what the status of your case is, and if they can file a contempt petition, they should do that. And I know it seems repetitive, but the more filings that we do at family court, the more that it gets before a family court commissioner, the higher penalty that a non-custodial parent may have to pay for their failure to pay their obligation. Another question. My child support order is an out-of-state, and the other state has given credit for visitation to the non-custodial parent. The non-custodial parent is not visiting. Do I have to change the visitation agreement, or can I go to the other state's child support agency? Is it a contempt or something when the non-custodial parent is not visiting at the center and getting monthly credit? Okay, so this is something that and you rightly so, you say this is an out-of-state court order. Every state treats visitation and they call it visitation and access programs, or how much and how they treat those visitation orders in conjunction with child support orders. So let me just first talk about Delaware. In the state of Delaware, the family court treats child support, custody, visitation, divorce. They treat all of those things separately. So we don't give non-custodial parents credit for visitation credit, access and visitation. It's kind of the terminology that the federal government calls it. We don't do that here in Delaware. And as you said, your order is an out-of-state order, and they must do something a little bit differently than we do. My suggestion would be this. We can certainly reach out to the other state if you're a client of the divisions, and anyone who's not a client of the divisions, I would recommend that you become a client of ours, because we can help you through some of these, some of the filings, and some of our enforcement tools will help collect some of this back child support. But if you're a client of ours, I would recommend speaking to a child support specialist, your child support worker, and we can reach out to the out-of-state agency and let them know. And Ms. Lynn, I would suggest that you provide your worker with a little bit more detail. We probably have your out-of-state order in our child support system if your case is coming through Delaware, and we could certainly get from you what exactly the non-custodial parent is not doing to follow the child support order as it relates to the visitation, and we would absolutely let that out-of-state agency know what he or she is not doing to follow that particular order. So we would certainly provide that information to the out-of-state agency in another state, and basically we would have to ask them, what do they do in this particular situation, and we would of course relay that information to you. So we would certainly help you through that process. Now, when you speak to a child support specialist here in Delaware, they may not know exactly what you're talking about because like I said, we don't do that here. But if you explain it like you explained it in this comment, and explain to us what exactly is not happening and what the other state is doing to give him or her credit for the visitation and access, we would definitely relay that information to the out-of-state agency. Is there any way that the child support order can be in Delaware and not the other state? And this is just a follow-up to Ms. Lynn's question. And unfortunately, if a non-custodial parent resides in a different state, it's got to be it's got to be that way if their order has already been created in that other state. If the non-custodial parent moved to Delaware, that's a different story. We could register that out-of-state order in the state of Delaware, not only for registration but for enforcement, and we could take over the enforcement activities. But ultimately, if the non-custodial parent resides in the other state and there's a court order in that other state, it kind of has to stay that way in order to make the process work correctly. Great follow-up, though. Great follow-up. Question here. Surprised it is not if the child and one parent is still in this state. So so just kind of follow back up. If the non-custodial parent lived in that other state, then normally we try to make it a Delaware order if the custodial parent's here, but there's a couple things that have to come into play based on some questions that we have to ask. And so sometimes it can be a Delaware case, but normally if it's an out-of-state jurisdiction and they have the court order and that non-custodial parent still resides in that state, it's usually a two-order. It's an out-of-state order process. Quit job to stay-at-home dad, no plans to be employed again. So this is a follow-up to the person who was working. We sent a wage withholding. They got the wage attachment, got to that employer, and the non-custodial parent quit that job. And the custodial parent saying that he quit the job to stay home, to be a stay-at-home dad. There's no plans for him to go back to work. And let's see here. Just want to make sure there was no follow-ups. So in that particular case, dad's staying home to be, quit job, staying home to be a stay-at-home dad. I'm sorry, but that does not work. That person is gotta pay the child support. So it's one of those situations where we talk about it all the time on these Facebook Live events. If the person is underemployed, unemployed, and doesn't try to find employment, earns a living by illegal activities, works under the table. Those are some of the hardest cases for us to enforce. And it's because there's no payroll company, there's no employer. And in those types of situations, really the only one tool that we have, besides intercepting their taxes, suspending their driver's license, we can send a filing to the credit bureaus to basically say that this person is bad. He's a bad credit risk. The only thing other than those types of our enforcement tools here is to generate contempt petitions with the family court. So he can choose to be a stay-at-home dad, but we are going to continue to file contempts. He will wind up being incarcerated because you know why? He has multiple families he needs to support, and we want to make sure that he's doing that. So we will use all of the tools that we have, whether they're automated enforcement tools or whether using the family court to find him in contempt. And eventually, unfortunately for him, the courts may choose to incarcerate for non-payment of child support. I think that the courts would say that being a stay-at-home dad is not an acceptable excuse to not pay child support. I want to make sure I didn't miss anybody up here. All right, great questions. Keep them coming. We're going to stay on a little longer today due to our technical issues. Here's a new question. Mother doesn't have child and is still trying to receive child support from the father. The father has lost his license because of this. We tried to go to family court to file for a modification to get the case dropped. And they told us we have to make an appointment to do that with his caseworker. So now great-grandmom is trying to take him for child support while mom that doesn't have the child is still trying to get the money from the father. How do we handle this? Isn't it fraud to receive money for a child that they don't even have and haven't had in years, but still trying to receive money for them? Okay, so there's a lot here, so I'm going to try and make sure I cover it. So if the mother no longer has the child, and the father is still trying to, okay, what should happen is this. If there's any documentation that shows the children went from mother to grandmother, or I'm sorry, great-grandmother, guardian, there's a custody order, there's a guardianship order, something along those lines, the father should file a motion to revoke the current support on the mother's case. And when he files that motion, and this is another thing too, that pro se office, the resource center at the family court can help him. He would want to attach any documentation that shows the children no longer reside with the mother and revoke that current support obligation. Now, the great-grandmom can certainly, if she has custody, can certainly go after both parents for child support. They can go after the custodial, the mother and the father for a child support order. Now, when the courts revoke the order, if they do revoke the order, choose to revoke it, they can go back effective the date that the child left mom's house and went to the grandparents' house. And it may show that the biological father, the father has overpaid the custodial parent, the mother, and he can go after those funds to have them returned to him. May require a filing within the family court to get that overpayment reimbursed to him, but that's something that can happen, and the mother would have to pay those that overpayment back to the biological father. But my suggestion would be to go to the family court in the county that this court order is in and speak to somebody at the resource center. And if there's any documentation that shows that the children went from biological mother to great-grandmother, attach it to the documentation, and the courts should intervene to resolve that current support obligation. One last thing, if the biological father, you can call customer service here at Child Support at 577-7171 and request an account statement. They can talk to a worker, and if he has documentation, he can supply it to us and we can file to remove that current support obligation. But they need to call the customer service unit at 577-7171, or like I said, go to the Family Courts Resource Center and they can help you deal with that. The next question, I don't think Delaware would agree with the credit with not visiting I am a client. So, right, so ultimately, but the court order is in another state. This has to do, again, going back to that visitation and the out-of-state, other state agency that has a court order gives the non-custodial parent credit for visitation against the obligation. So, right, we would communicate with that other state, but it's because it's the other state's order, they have control over what they're going to do related to visitation and how that works in their jurisdiction, and we would have to abide by that other state's court order. So I hope that helps. But certainly, like I said earlier, reach out to your worker and give us all the information. Give your worker all that information, and they would certainly talk to that other state and get more information about the credit as it relates to visitation and be able to work with that. work with that other state to make sure that, at a minimum, that they know what's happening here in Delaware as it relates to visitation. Okay, so we got another question. What happens now when a non-custodial parent overpays or the employer takes out too much money and it leaves a credit that parent be able to recoup the overpayment? Okay, so a lot of times what happens is an overpayment can occur when the courts give let me back up a little bit. If a non-custodial parent, say, loses loses a job and gets a new job, and he's not or she is not making as much as in the first job, they can file to modify their order, or at any time they can file to modify their child support order. If the courts go back retroactive, so they go back in time, we at the Child Support Office will credit, and it may in some cases indicate an overpayment of arrears. So let's just keep it simple. Let's say, for instance, the order is $100 a month, and the courts modify that obligation to $50 a month. And they say, we're going to go back 8 months. We would go back and, at the rate of $50 a month, credit the account. So when an overpayment occurs, and the money isn't sitting here at the Child Support Office, the money has come in and gone out to the other party over time. What would have to happen is the non-custodial parent can file within the family court to have that overpayment paid back to him by the custodial parent. And normally what the courts will do is they'll go ahead and say that that the obligation is going to be reduced by a certain amount. They'll say, okay, child support, the new order is for $50 a month. Issue a wage attachment, and this is all hypothetical, issue the wage attachment to the employer for $45 a month and have the credit eaten up every month at $5. So there's ways that the courts can work with both parties to make sure that overpayment is dissolved. Or the courts could say, Mom, you have to pay back, non-custodial parent. And, they set up a payment process, a payment plan to get that done. But because those funds are not here at the Child Support Office, we do not, and we are not, and basically it's in Delaware law. The Delaware Child Support does not have to reimburse non-custodial parents for overpayments that have been paid to the custodial parent. And that's because the monies aren't here. We don't have the monies to pay them back. They just get, the courts will issue a new order to try and deal with that overpayment, or will order the custodial parent to pay the non-custodial parent back directly. This is just a follow-up to an earlier question. I've not been provided my case number, and not sure if that comes through my attorney who prepared everything, or if I get mailed something. Or do I need to reach out to Child Support Office for the case number? So yes, if this is what I would do. First, look at your court order from the family court. And if it said that the payments were going to come through the Child Support Office, there's a case number sitting here for you. So my suggestion would be to call customer service, 302-577-7171. Give them your name and they'll probably ask for your social security number or your date of birth, and there will be there should have been a case created for you, and they can give you that case number. But absolutely call our office, and we can give you that. The next question is it true that if you have more than 3 kids, the rest aren't allowed to be added on a child support order? Absolutely false. Now there are some situations, and when I first started this Facebook Live event today, I was talking about how people become clients of ours, And what I already talked about was receiving an application. We can send you an application. You can come and pick one up at our child support office. This does kind of apply to this question, so I want to make sure I follow up on this. There are cases that come to the child support office where a custodial parent is a client of the Division of Social Services and they're receiving TANF benefits. We automatically get a case from the Division of Social Services. Those custodial parents are automatically clients of ours because we try to recover funds to pay back to the state of Delaware. Now, what does it have to do with this question about the number of children and whether they're allowed to be on a child support order? There are a certain number of, there are what they call CAP kids, and I'm not sure if this applies to you, but there are a certain number of, I'm not quite 100% sure about CAP kids, but there is, I think, a limit as it relates to the number of children that are open on a TANF case and that will be attributed in a child support order. But those happen very rare. They're very, very rare situations, and I'm not sure that would apply to your particular situation. But we have child support cases in our system with 6 kids, 7 kids, 8 kids. We have non-custodial parents that have multiple cases. So no, the courts will create an order regardless of the number of children who are in a household or in a family. So I hope that helps. Does the state still send the non-custodial parents to work release? So, as we've already talked a little bit, when an individual is incarcerated for non-payment of a child support order, most likely they're going to be sent to the Department of Corrections at level 4. And what level 4 is work release. And there are 4 level 4 facilities here in the state of Delaware. And yes, so the answer to your question is yes. But that only happens when the non-custodial parent is incarcerated by the family court. They're the only entity that can incarcerate someone for non-payment of a child support order. And they will be sent to work release. And they do have counselors at level 4 to help them find employment opportunities. And we can help them find employment here at the child support office and we try to work with them to help non-custodial parents become employed. So I hope that helps. But we don't like to see people become incarcerated because that really doesn't help. It doesn't really help anybody. You know, non-custodial parent can't work, custodial parent can't get money and that kind of thing. So we try to work with them, but they do have a work release program at level 4 facilities. Next question. When the child support order was done, the obligor had to provide proof of income, but the parent receiving did not. Oh, hold on one sec. Jumped a little bit here. Sorry about that. When the child support order was done, the obligor had to provide proof of income, but the receiving parent did not. The calculation was based off of what the receiving parent verbally stated was their income. Why did the receiving parent not have to provide proof of income? So let me say this. I don't know the answer to that. Normally, the courts will ask, and you know, I know I'm sometimes sounding like a broken record because I've said this, I know, 100 times on these Facebook Live events. The courts, for any kind of a court hearing, are going to tell both parents, please bring with you financial information, 3 pay stubs, a tax return, to prove what your income is. And they will use that income to do the child support calculation. That's why I always tell people, if you get that letter and it tells you to bring income verification, bring it with you to the family court. Now, in some rare, in some situations, I don't want to say rare, in some situations, if the child is with a guardian or a grandparent, they will not ask that parent to bring in financial information. Only biological parents are asked to do that. So, if the parents do not bring in information to prove what their income is, the courts will use the Delaware labor standards for various pieces. I always joke about it a little bit. It's a big book that they open and say, you say you're a receptionist, and they look in the book, and that book that tells them what a receptionist makes or earns here in the state of Delaware. They get the information from the Labor Department. So I don't know if the court used that standard to try and prove income, but that may be one thing that they do. But it's always wise for both parents to bring that financial information, because you want it to be that child support calculation, you want it to be a true representation about what you earn, as you're from an employer. So it's always important to have that information handy. So just keep that in mind when you're going to court, to make sure you bring that information with you. So the next question. I was told great-grandmom has guardianship. This goes back to a previous question, but she is only going after father and not the mother for child support. Can he object to that when he goes to court mediation, that she needs to go after both parents? He can certainly bring that information up at mediation. What I would also suggest doing is, certainly the grandmom should go after, pursue child support from both parents. I think that certainly is certainly something that is in her best interest, to support that child that's not hers. But yeah, absolutely, you could bring it up in mediation. I'm not guaranteeing what kind of a response you're going to get. And then certainly that information can be provided to the child support office. If the great-grandmom is open on benefits at the Division of Social Services, then I believe that we would get a case in our child support office about both parents. So, and we would pursue it from the biological mother and from the biological father. Let's see here. We're kind of running close to the end of time, so I want to make sure. Thank you for all these great comments. We certainly want to be able to help you with your child support. That's great stuff. The next question is, what is the name of the petition to have a child support revoked, and how is it different from child support modification petition? So in order to revoke the child support order, that's actually done by a motion, and it's a motion to revoke at family court. And they have forms of family court that you can fill out. Or if the child is emancipated, you can certainly contact the child support office, and if your case is a child support case, here in our office we can help by filing the appropriate documents with the family court. A child support modification petition is a petition that someone, let me back up. To modify the current obligation, you would file a child support modification petition. That can be done every 2.5 years, or it can be done whenever there's a substantial change in your circumstances, financial circumstances. So you lose a job, or you got a promotion, and it's going to result in a modification of 10% more than what you're paying now, either down or up. You can file a petition for a modification. The revocation is when you want to remove the order, and it's done by a motion, or we at the child support office can file a notice of administrative adjustment to revoke the obligation if it has been paid in full and the children are emancipated. So that's the difference. One is done by a motion, and the other is a motion to revoke. And the petition to modify the obligation would just change the financial amounts. based on a financial circumstance. The next question is, when arrears are paid in full, how do you go about having the wage attachment changed to stop the extra arrears payment? So similarly to what I've just discussed, if it is a case here at the Child Support Office, we can file a notice of administrative adjustment with the family court to let them know, hey, the non-custodial parent has met that arrears balance, paid it off, and we want to modify the obligation to just current support only. And we can do that for the non-custodial parent. Just call our office and we can help them do that. Or the non-custodial parent can go to family court and ask for a motion to revoke the arrears payment. The good thing about both of those documents is it does not require a hearing. The courts would review the filing and look at a child support account statement and see that the obligation is paid in full, or they, and go ahead and just revoke it, and then tell us to issue a new wage attachment for just current support only. And then if there's any funds here that were meant for arrears and they're like an overpayment, we can return them to the non-custodial parent, or we could just apply it to the current support obligation. And I always like that idea because it always puts that non-custodial parent a little bit ahead. Money kind of rolls over. But it's file a motion to revoke the arrears payment, or child support can file a notice of administrative adjustment on your behalf, and we would send a new wage attachment to that employer for current support only. Got a new question here. Let's see here. When taxes are withheld from the non-custodial parent, how does Delaware handle sending the custodial parent when there are more than one? What is the average time for distribution once intercepted? So when we intercept a non-custodial parent's taxes, we will apply those payments to all of his cases, and we will the child support system, based on federal requirements, will distribute those payments accordingly amongst all of his obligations. The only time we are required to hold a tax intercept is when there is the non-custodial parent has a current spouse, and any of that tax refund may be owed to that current spouse. And that spouse is entitled to receive their portion of the tax intercept, and we're required to hold that money for 6 months. And we hold it for them to file an injured spouse form, and the funds can then be returned to that spouse. So that's how it's done. So we have to disperse it amongst all of the cases, and the only time we hold it is when there's another spouse involved and they're due their portion of that refund fund. There's another question. Let's see here. So I hope that answered your question about just distributing. We have to distribute those taxes amongst all of the cases. Does the custodial parent's income play a role in child support, or is child support about looking at the expenses and the non-custodial parent's income? It actually deals with both. Yes, custodial parent's income does come into effect, and expenses come into effect, and the non-custodial parent's income comes into effect. So all three things do come into effect. Is there a lawyer or GAL that helps with legal services for child support for the child when it is an out-of-state case? So here in Delaware, the Department of Justice represents the child support program. And they are our attorneys, and they help us process child support cases and do represent the child support program when they go, when child support custodial parent goes before a family court commissioner. In other jurisdictions, in other states around the country, it is similar, but somewhat different. Each state is different on how they manage their child support case processes, but there are child support attorneys in all jurisdictions that help with child support cases. They may handle them a little bit differently than Delaware, but there are child support cases, child support attorneys helping us in all the states around the country enforce those child support orders. And we're going to kind of wrap up soon. I think there's two more questions, one more question, and then we're going to go ahead and conclude for June. And I apologize for our tardiness today. We had some technical difficulties, and we're going to try to avoid that next month. Remember, the Child Support Connection, the first Monday of every month. You can share this information with people you know that may be interested in child support, and they can join next month. And especially if you know non-custodial parents, feel free to have them tune in, because we want to be able to provide them with information about child support. Okay, so this question is kind of lengthy. I'm going to read it and provide you with hopefully an answer. And if not, we can certainly find out an answer. So Title 4D, and Title 4D is the program that governs the child support program at the federal government. It's Title 4D of the Social Security Act. It says a court orders a child support order. Dad or mom pays the child support order. The state turns in a bill for the collection of said child support. They bill 66 cents on every dollar spent for child support for the collection of child support. This means that 2 out of 3 persons working for the collection of child support for the state government is funded to be there by the federal government. The money can also be spent to collect child support. The child support division workers, if the state collects enough child support to meet enough criteria, the Fed offers a bonus paid, blah, 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 blah. Yep. The state are funding their child support government off of the child support federal reimbursement, plus some states' child support late fees. Yeah, not Delaware. Delaware does not collect interest. We do not have collection fees, etc. Okay. The yearly payout of federal monies to be split amongst the... Okay. This is a big business. Now you know why you can have to be a visitor to your child because... Okay. So I guess there's not a question here. Thanks for the information. I'll leave it at that. Thank you for that. Very informative. In previous years, we've been child support split amongst cases and no current spouse. Hold for 6 months. One time. Oh, Newcastle received notice. Okay, so I've answered the question about the taxes. Gentleman this person provided some great information about the child support program. Just want to make sure this last question about the taxes. In previous years, there have been the case. It has not split amongst cases, and there is no current spouse. There has been a hold for 6 months one time, no hold at all. Newcastle County has received notice of intercept but distribute. My suggestion would be this: why don't you go ahead and send us an instant personal message, and we can certainly try to respond based on your particular case. You know, there's a lot of cases that are different. But we certainly want to make sure that, depending on the criteria for the tax intercept program, did your case meet that criteria? So there's kind of some outliers, and I certainly want to make sure that we address your case specifically. So feel free to contact us at the Child Support Office. I want to thank you all for these great questions. Tune in next month. On Wednesday, the third Wednesday of the month, which is going to be June 15th, I'll be on 92.7, 98.5 WGMD check out their app. If you live in Newcastle County, you can check out their app and listen and tune into the questions we get on the radio with Jake Smith down in Sussex County. Thank you all very much. Tune in next month for the Child Support Connection in July of 2022, the first Monday of the month. Encourage your friends to listen. Have a great day. Stay safe.